Good morning. Welcome to the Cobb Law Library. I am Kim Isaza, the director of the library. I don't know if everyone knew that the library existed, but we are a place for legal research for the community. We are here in Superior Court on the 4th floor, and we are open Monday through Friday, 8 a.m. to 5 p.m. And today I'm delighted that we have Amanda Mathis Riedling with us. She is a partner in the firm Georgia Wills, Trusts, and Probate Firm, LLC. This program is being recorded. It will be posted on the Cobb County government's YouTube page for subsequent viewing. And Ms. Riedling is going to tell us about the 3 essential estate documents: wills, financial power of attorney, and Georgia Advanced Directive for Healthcare that everyone needs. And she's going to explain why we need them, and the nuts and bolts of getting yours in place so that your wishes can be followed, essentially. If you submitted a question with your registration, she has those and will do her best to answer that. Please be aware she cannot answer specific legal advice questions. She can only present legal information in a general format. And so with that, I turn it over to Amanda. She is a Cobb County native and a graduate of the University of Georgia Law School and has been practicing fiduciary law for more than 10 years. About 10 years,
yeah.
About that.
Yeah, no, just a little more than 10 years, coming up on 11. But anyway, well, thank you all for being here. Good morning. And thank you, Kimberly, for allowing me to do this. This is her brainchild and getting the word out that the Cobb Law Library is here and available to our community. So I think it's great, and I'm honored to be a part of it. So a little bit about me. You already heard a little bit, but yes, I was born and raised in Cobb County. My parents still live in the same house I grew up in. It's the same house my dad grew up in Ackworth, Georgia. And his family came here to come and work at Lockheed years and years ago. And then we stayed. So I went to North Cobb High School, and then to the University of Georgia, where I did a finance degree and also my law degree there as well. So. And I am an owner and partner in the Georgia Wills, Trust, and Probate Firm, as you can see. And I've been an owner for about 5 years. Before that, I was an associate attorney. But again, I've done nothing but this area of law my entire career. So I love talking about it. I'm willing to talk to anybody who wants to listen about this kind of thing. So, all right, so enough about me. That's not what y'all came for. I want to talk today about the 3 most important estate planning documents that everybody needs in the state of Georgia, no matter what. These are the most important things, the very base level of estate planning. Now, there's lots of more advanced estate planning that takes into account avoiding probate or taxes and Medicaid planning and all that stuff. That's not the topic for today. If you have questions about it, I'm happy to answer those if I can, but the main topic, again, is the base. What do I got to have to make sure I'm checking the main boxes? So again, the first one is a last will and testament. So most people have a general understanding of what a will is. The 3 main purposes are, first of all, you get to choose who inherits from you. Because if you don't have a will, guess who chooses? The legislature. There's laws that say who inherit from you if you don't choose yourself. And it may not be what you think it is. One huge myth, if you're not familiar with this area of law, is, oh, I'm married, my spouse inherits everything. Not necessarily true. Your spouse inherits everything unless you have kids. If you have kids, it's spouse and children. It doesn't matter whether they're minors, whether they're adults, it's spouse and children. So a lot of people will end up not doing estate planning because they think, oh, I'm married, my spouse will get everything and all that. If they unfortunately pass away, their spouse ends up owning their property with their kids, potentially minor kids. And there's a whole lot of issues that come along with that. So you got to have a will to say you have a say who inherits from you, and you put that in writing. The second thing is you want to have a say in who's going to be the one managing your estate. You want to choose your executor. That's the person who will step in, probate your will. If that's needed, they will gather up all your assets, figure out what all your final bills are, get all of those paid, and then distribute everything according to your will. Okay. The third main reason, especially if you have minor children, is to name a guardian of minor children. One huge benefit of a will is you get to say who that is. If you don't, you could end up with two families who love this child fighting in court over who's going to be their guardian potentially. And so if you say who that is, you get to choose and have more of an impact on your child's life if something tragic happens and you do pass away with minor children. I understand these are things that nobody wants to think about, nobody wants to acknowledge that those things happen, but they unfortunately do, and so planning ahead is one of the best gifts you can really give your family. So what does a will need? So I've got an at a minimum slide, and then I've got a, on top of that, you should do this too. Okay, so at a minimum, you've got to have legal capacity to make a will. So first thing is you got to be old enough, and believe it or not, the age in Georgia is 14. So you only have to be 14 to make a will. You also have to have the mental capacity to make a will in order for it to be valid and not potentially attacked by anyone that wants to contest it. So the bar is not super high for that, but you do have to be able to answer some basic questions without help or prompting. You need to be able to say who your family members are. I'm married to this person, I have this many kids, I have this many grandkids, here's generally how old they are. You need to know what assets you have, because how can you legally give it away if you don't know what it is, right? How can you make a determination about that? And so you need to be able to say, well, I own a home, I have bank accounts, I have about this much money. You know, it doesn't have to be exact, but you do need to be able to express that. Again, without help from family members and prompting. And then, of course, you don't want to have any undue influence. So that means that you don't need to be doing it because someone has encouraged you to do it unduly. So a little encouragement is fine. But you know, holding things over your head or putting ideas in your head and those sorts of things. Folks with a weaker mentality are subject to something like that. And so it is a grounds for a contest of a will if the will is created under those circumstances. So, so those are the bare minimum for legal capacity. Then of course it needs to be signed. There's some exceptions to this that I don't want to go into today, but generally it needs to be signed. It's very hard to probate a will if you haven't signed it. Not impossible, but very important. It needs to be witnessed by two disinterested persons. So what does that mean? It means they're not a beneficiary of your will, you haven't named them as an executor in your will or guardian. Now legally, as long as it has two witnesses, it's fine, but it's best practices to not name those people because you could end up either disqualifying that executor or disqualifying that person from inheriting from you. So again, for it to be legally binding, as long as you have two witnesses, it's fine, but your wishes may not be carried out if you do end up using your executor or your loved ones or your children or grandchildren, things like that as your witness. So this next one, you want to have what's called a self-proving affidavit. So this is where your two witnesses will sign it in front of a notary. You will also sign it in front of a notary, and it has very specific instructions about what happened at the signing. The testator signed it. They signed it in front of the two witnesses. The witnesses saw the testator sign it. The testator saw the witnesses sign it. You don't have to recreate this. There's a standard form in the statute, so this is something that the legislature has already drafted. It has all the things that it needs. So if you are going to probate a will in the state of Georgia, you really need to have the state of Georgia self-proving affidavit. Part of my practice is also probate work. So I help lots of families through the probate process, even if we didn't do their will or if they have an out-of-state will, let's say from Illinois or California or Florida. Not all states have the same requirements. So if you've moved from out of state and you have an out-of-state will, it may or may not work with the self-proving affidavit that you had there. So you can still probate it, it just makes it harder because you have to go find the witnesses to get that affidavit later, which is really fun to do when you're probating a will from the 70s, which I've done multiple times. So it just makes it harder. So you want to have the Georgia version of the self-proving affidavit so that you're making it easier for your executor to go through that probate process. It also makes it cheaper and quicker. And the probate court will love you if you have all that stuff done right too. All right, the line of sight test. The testator, the witnesses, and the notary need to all be able to physically see each other when you're signing the document, okay? So they call it the line of sight test. So even if you're over there and you physically could turn around and still see the person sign, that counts as being, as witnessing it. Logistically, you're all signing it anyway, so you really need to be in the same room, but that's required as well. Of course, you want it to be dated. The reason is, what if you change your mind? Wills are completely revocable. You can undo it. You can revoke the old one, do a new one. So you want to make sure your family finds the last one and you've got the dates on there to show which is the last one. Just a practical tip, if you do revoke a will and do a new one, destroy all evidence of the old one so no one accidentally finds the old one, right? Okay. Some other stuff, again, those are sort of the basic things to make it valid, that whatever you put in there, your wishes will be carried out. On top of that, I put it as at a minimum because it really makes the job of the executor a lot easier, is you want to waive the requirement in the document. You want to have a statement that says that you waive the requirement of your executor to post a bond, to file inventories, returns, reports, and statements. So what does that mean? A bond is essentially an insurance policy that a fiduciary is required to get under an estate, unless there's an executor where it's waived, right? That insures the estate. So if the executor were to do something intentionally wrong or even accidentally wrong and they take all the money or they accidentally distribute it to someone they're not supposed to, that bond will then come back and make the estate whole. But they go after the executor, right, or the fiduciary for what they did wrong. So they're not off the hook, but it helps the beneficiaries. So the idea of waiving it is you've picked someone you trust. You also don't want them to have to worry about logistically getting it. You have to actually go to the insurance company, get the bond, and then you have to pay for it, and the premiums can be expensive. So by waiving that, you're helping your executor with the probate process, making it cheaper, quicker, and easier. Because what are we talking about here? We're talking about you've passed away. So they're probably grieving and things like that. So you don't want to add more to their to-do list unless it's something you truly want. If you want them to post a bond, that's different. Or if you want them to file reports, that's different. But again, and then waiving the inventory. So an inventory is a requirement of an executor or a personal representative of an estate to file with the court, which then becomes public record. You can go look it up on the internet right now if these are required in an estate, of a list of all the assets that were found in your estate. So you lose all privacy there if privacy is important to you with what assets you have in your estate. So by waiving that, again, taking one thing off the executor's to-do list and making it cheaper, quicker, easier, and more private. Same thing with returns. So in addition to that first inventory, every year, a personal representative of an estate, unless it's waived, has to file a checkbook analysis of every single dime collected or spent on the estate once a year. There's filing fees for that, so you've got cost. It's another task for the executor to do. Hopefully they kept good records and can actually reproduce all of that. But again, it's just adding more to their job, adding more to the expense. A lot of times people end up having to hire an attorney to help them with those things. So again, you can waive that if it's not something you want, okay? Same thing with reports. Now, statements you may or may not want to waive. Statements is where they're required to provide information to the beneficiaries of, here's copies of all the estate bank account statements and transparency. So that one you don't necessarily have to waive, but it's there if you want to. Usually sharing information with the beneficiaries is a good idea. You don't want to take that off the table. So we've talked about that you need to name an executor, you need to name a guardian. This is a big one for me as a probate practitioner as well. You only want one of what's called a residue clause. If you've ever read a will, there ends up being this catch-all phrase somewhere on it that says, all the rest, residue, and remainder of my estate, however situated, real, personal, all that. If y'all have ever read a will, you see that. It's really hard to determine what someone wanted if they have two of those and they compete with each other. And it's weird, but I see it all the time in people that draft their own wills because they just see a spot for a beneficiary and then another beneficiary and they don't realize, oh, these are the same thing, and they compete with each other. That's how you create probate litigation. So make sure you only have one residue clause. And then along the same lines, you don't want any conflicting provisions. So if you've said, I want my car to go to this person over here, don't give it to somebody else over here. Don't say, I give my house to this person, but then after that, put all these restrictions on it. That creates ambiguity, and you know, that makes it hard for people to know what exactly were your wishes. So it needs to be very, very clear. This is where I typically recommend an attorney help you. If you do have anything other than everything to this person, otherwise to this person, please have an attorney help you with that, because again, through my probate practice, I've seen lots of families where maybe the wishes couldn't be carried out the way that they thought, or it created litigation because it opened the door for someone to come in and argue, well, no, they meant this, not that. It's supposed to come to me, not you, that sort of thing. So that's at a minimum. I know it's a lot, but bare minimum in my opinion. Okay, so on top of that, you want to also think about, how are your assets titled? That is what is really going to determine how things pass. So a will is just one tool to pass assets to loved ones. You want your will to match what your joint ownership of accounts and real estate has. You want it to match, or at least cover your wishes for any beneficiary designations you have. So when you have, especially like IRAs, 401ks, life insurance, those typically want you to put a beneficiary when you get them. If you've put someone as a beneficiary, but then you put someone else in your will, the beneficiary is going to govern. The idea is you want them all to work together. You still want to use beneficiary designations. I'm not saying don't use beneficiary designations. Absolutely use beneficiary designations. Be careful with them, but make sure that your plan all works together and your wishes are governed each asset. A little thing about joint assets here. Another huge myth is that if you own real estate jointly with someone and you pass away, that other person automatically inherits that half of the real estate. Maybe so, but maybe not. It is not automatic. Your deed has to have the words joint with rights of survivorship. Again, joint with rights of survivorship. If your deed says that, then yes, if you pass away, the other joint owners inherit that property outside your will. So again, in your will, if you want someone else to inherit that property, you need to make sure it doesn't say that, right? If it doesn't have that language on it, then your half of that property, or your percentage of that property, passes under your will. It's got to be probated, all of that. If you don't have a will and you just assumed it would go to your spouse may now own your house with your children. That could include stepchildren, maybe you didn't intend to include. It could include minor children. So be very careful with joint ownership. Look at the deed. You can go home today. You can find them online. Or the deed office here in Cobb County can help you, or an attorney can help you. Get a copy of your deed. Look at it and see what it says. And then certainly you would know, okay, do I need to have a will for this? Do I need to change the kind of deed I have? Stuff like that. So again, overall, just make sure your beneficiary designations and your joint ownership work with and match your wishes for your will. For spouses and minor children, there is something called years support, Y-E-A-R-S. This is an election that spouses and minor children can make to have debts or creditors of that deceased person set aside, and have it to where the spouse and the minor children get those assets instead. The idea is we don't want spouses and minor children left destitute because there's some tragedy or there's some long illness where there's just tons and tons of medical bill debt. So you are not responsible personally for any expenses that are just your spouse's expenses, or just that person that's passed away, their expenses. Their estate is, but you personally are not. So what this does is it helps the spouse and minor children to say, okay, creditors, the spouse and minor children can be taken care of first. It can be a dollar amount. Sometimes it can be the whole estate. I could do an entire presentation on year support, but address it in your will, whether you want your spouse and minor children to be able to elect it or not. This is something that a lot of standard forms that you find that are just general don't address it, because it's very specific to Georgia. Almost no other state has that. Or if they do, they don't call it that. So address whether you want them to have that or not. I typically start with the premise that you do want your spouse to be able to do that, or you do want your minor child to be able to do that. My opinion would be different in blended families, because if you have a blended family and you want to make sure that your kids from a previous relationship are cared for first, or in some way, maybe you don't want your spouse to be able to go and claim that. So it's definitely something to think about. There's not just one answer that applies to everybody. Backup executors. You want to make sure you name, at least have one. That's on my bare minimum slide. But you want to have at least another backup, because what happens if you're traveling with that person and something happens to both of you? So make sure you have backups. You can put as many backups as you want. I would say minimum of 2, maybe 3 if you already know you have those people to trust, okay? Plan for contingencies. Same thing with having backup executors. Think about backup beneficiaries. What if my beneficiary passes away? If you don't say in your will who gets that property, we go back to that statute I told you about where the legislature chooses for you. And again, it may not be what you think. Typically it goes spouse and minor children together. And then if there's no spouse, then all to children, or not spouse and minor children, spouse and children of any age together. If you only have a spouse, all to spouse. If you only have children, equally to children, so on and so forth. There's lots of rules about if you have a child that's passed away with grandchildren, it trickles down the family line. Then you get to parents, if you don't have a spouse or children, then siblings, then nieces and nephews, so on and so forth. So that's typically what it is. There's lots of nuances in there, so if you're interested in who would inherit from you without a will, definitely talk to an attorney. So put in your will, if my spouse does not survive me, then it goes to my children, my sister, my parents. If you're giving someone something specific, like I want my diamond ring to go to my niece so-and-so, always put after that, if she survives me, because there's statutes that say if you don't have that survivorship clause, there's a statute that says where it goes if they don't survive. And again, it's probably not who you want. So be very, very careful if you're drafting your own will. And even if you have an attorney drafting for you, these are things to be on the lookout for if they don't know to do it. So then we get to the doomsday provision. What is that? That's how they teach it in law school. So the doomsday provision is what happens if every single beneficiary you've named in your will passes away either at the same time as you or before you, and you don't update. That's where we go back to that statute. It's called the intestate statute that I've referenced a couple times. It just goes to that person unless you put something. So I have lots of people at that point that will pick a charity or their alma mater or set up a scholarship, just a catch-all so that they never get to that intestate statute unless they're fine with that. I have lots of clients fine with that. They say at that point, I don't care, whoever's next in line, according to the legislature, they can have it. I won't be here, so I get that a lot. But if you do care and you're charitable minded, you can do things like that. I've already mentioned this, assets passing under your will have to be probated first. Another myth is when you pass away and have a will, your executor can just take that will and go do things. And they can't. They have to file it with the probate court, pay a filing fee. There's all sorts of legal notices to your next closest relatives under that intestate statute I talked to you about. And then they have to wait on a court order. They'll get a court order as long as everything's good and nobody objects and all that. Then they can go do things. So that's another myth that I want to clear up. Again, beneficiary designations are a good way to avoid that. Beneficiary designations are automatic. Joint ownership with rights of survivorship is automatic. Again, these are just assets that are just in your name, no joint owner with rights of survivorship, no beneficiary. Those are the assets that pass under your will. I like to hit on this one about your deed. A lot of people will say, oh, well, I'll just add my child to my deed. I'm sure everybody's heard that from a friend or a neighbor or their church or something. Don't do that. This is my recommendation. Again, this is not legal advice. This is just general information. This is my opinion. Capital gains. When you pass away and your family inherits from you, they inherit your home from you, they get a step up in what's called basis to where the whole tax on the appreciation of that asset gets a restart. Well, if you gave it away years ago or you put someone's name on it, guess what? No, they're going to have to pay the capital gains now potentially. So that's under today's laws. you now no longer control that property. What if let's say you put your child on your deed and they get sued? They own half of it, or whatever percentage you put them on. What if they're going through a divorce? What if, there's just all sorts of reasons. And actually, let me make sure I hit them all. You can't sell it without them coming to the closing and signing, and guess who gets half the money? Now, they may turn around and give it to you, but then you've got gift tax implications, right? If you give away anything over $15,000 to any one person in 1 year, you have to tell the IRS you did it. So if you're adding someone to your deed, you got to tell the IRS you did it. It's a gift of whatever value they got. And so be aware of that too. I think that covers all the don'ts for that. This is one of my things. I get calls all the time. I need to add my daughter to my deed. I need to add my son to my deed. And I say, nope, I'm not helping you do it. I don't care how much money you're willing to give me. I'm not going to do it. Minors should never be direct beneficiaries without an adult listed on the beneficiary designation as their custodian. Make sure when you're doing beneficiary designations, you name that adult. Why? Y'all heard of Britney Spears and her conservatorship? I know this is a little bit different because minors are hopefully not going through something like Britney Spears, but it's that same process that we all saw publicly. It's a conservatorship where an adult has to go to probate court, petition to be in control of that minor's funds, and it's expensive. There's filing fees. They have to post a bond. There's no waiving the bond there that we talked about. They have to do reports. There's no waiving those. And it's very, very expensive. Also, that money has to sit there usually until that child turns 18, and then they get a big old check at 18. You cannot touch it. The conservator, whoever the conservator is, cannot touch that money for the minor without a court order, which guess what? Is expensive, time consuming, and the judge may say no. So I've seen so many family members go through this, and it's gut-wrenching when I'm helping them through it because I can't necessarily fix it. So if you're going to name a minor as a beneficiary on a life insurance policy, an IRA, a 401k, name an adult as the custodian. Then that custodian gets to hold that money outside of a conservatorship, and they get to hold it till age 21. So it helps get that child to be a little older and protect that money for them. They also don't have those restrictions of not being able to spend it for their care because they're probably going to need it, right? So definitely be very, very careful of that. And definitely never put a minor as an owner of your real estate. I know we already talked about not putting anybody unless they, like your spouse or someone bought it with you or whatever. But definitely no minors on real estate. All right, I'll get off my soapbox on that. Okay, so any questions about wills before I move on to powers of attorney? Yes, sir.
I was in another session that a financial planner did one time, and they were talking about how you should have maybe a trust so you can escape all the cost and time of probate. If you don't have complications and you have a will and all that, how long should it take really? What's a simple probate?
So I love when people say simple probate or simple will. No, I know.
Everything passes by beneficiary.
Okay, yes.
There's no minor children.
Got you. Okay, so if you have everything set up by beneficiary designation and joint ownership, it's great. It just happens automatically. There's not much to do. So in that case, no, you wouldn't necessarily need a revocable trust to avoid probate in that case. Anytime you have real estate, though, you can't put a beneficiary on real estate, at least not in the state of Georgia. There are states that allow that, not in Georgia. The way to kind of back and do that is to create what's called a revocable living trust, which I believe is what you're talking about. There's lots of different kinds of trusts, but if you put your home or assets in a revocable living trust, it avoids probate after your death because trusts are not governed by the same sets of laws. They have their own laws that don't require probate. So a revocable living trust is not for everyone, especially if it's super, super simple and you can use beneficiary designations and that sort of thing. Even if, let's say you do have a home and you don't want to do the revocable living trust, but it still requires probate, everything you set up by beneficiary designation will still pass outside of probate. So your family will still have access to all of that in the meantime while they're probating for the real estate. Now, one thing about probate that makes it either simple or not is your heirs, which are the people by statute that I said you inherit from if you don't have a will, they all get notice of your probate whether you put them in the will or not. So even if you're disinheriting all your heirs, they still have to get notice, either sheriff's service of the petition or maybe get their signature for their consent, things like that. So that's what makes probate take longer, is more so who your heirs are, not so much what assets are passing under the will, if that makes any sense.
Well, when you say the heirs, do you mean everybody down the whole chain of the intestacy law, or just people who are named in the will? And what's the difference between common and solemn?
Okay, so heirs are, it's not the whole line that I told you about. It's you get to the level where you have someone and then you stop. So if you're married with children, your heirs are spouse and children. If you don't have a spouse or children, then it goes to parents. And then you stop there if you have parents. If you don't have parents living, then you go to siblings. If you have siblings, you stop there. So that's how you determine the heirs. So let's say you left everything to charity and your siblings are your heirs. Your siblings still get notice of the probate. They get an opportunity to object if they want to, hopefully not, but it almost invites an objection. So does that answer your question about who the heirs are and who gets notice?
Yeah.
Okay, good.
So far, I don't have to tell anybody I don't want to.
Good. So then the second question was, what's the difference between common form probate and solemn form probate? And I'm so glad you asked this because it's kind of messed up, actually. Common form probate is not the one you want, even though they call it common. It's more of a common law that came over from England, right? But it's not the one you want typically. Typically, you're going to want to do solemn form probate, and that is where you have to give notice to the heirs. Common form, you do not have to give notice to the heirs. But with common form, you can't typically get title to sell real estate, and nothing is conclusive for, it's either 4 years or 5 years. I want to say 4 years, but it could be 5 years. What I mean by that is everything can be undone in that time period. So let's say you probate in common form, you don't notice all the heirs, you distribute all the money. 3 years later, that sibling or that heir comes forward, whoever it was that was supposed to get notice, doesn't like what happened, they still want to contest the will, well, they can, and then you have to undo everything. So that's why practitioners like myself typically will say, if there's not a big deal, let's do solemn form. Common form is just quicker, it is cheaper and quicker, but you don't get as much authority and power that you do with the solemn form. Did that answer your question? Okay, good. All right, so moving on to Georgia Power of Attorney. So this is the second document that everybody needs no matter what. So we've talked about what happens if you pass away. We are switching gears to talking about what happens if you are alive, but you are incapacitated. You can no longer manage your own affairs. You are in a coma in the hospital for whatever reason. Maybe you have very advanced Alzheimer's or dementia and you're just not capable of taking care of your finances. Someone needs to do it for you. Well, you want to choose that person, right? Because if you don't choose, it's a free-for-all. Anybody can just raise their hand and do it for you. Again, think Britney Spears. You know, I hate all that happened to her, but it helps me explain all of this to folks. Okay, so again, the main things for that is you want to have a say in who's going to have access to your money, who's going to be paying your bills, who's responsible enough to do that, and who's going to be trustworthy. You also want to have a decision about how much power they're going to have. Do you want it to be limited? Do you want to let them do everything? And then what are some extra rules maybe you want them to have? Do you want them to have to do an accounting or report to a third person once a year for checks and balances? Maybe so. When do you want it to be effective? Do you want to actually have to have evidence you're incapacitated before someone uses it? Or are you okay with them just using it when, and you trust them to only use it if you're incapacitated? These are all decisions that you should make, because if you don't make them, you end up in that conservatorship process where any person that's qualified, meaning they're basically an adult with a pulse and, you know, is okay with money and doesn't have a super bad criminal record, they can just raise their hand and say, I'll do it. It could be a neighbor, it could be a friend, it could be someone who's maybe taking advantage of you. So you want to make sure that you have had a say in who that's going to be. All right, so again, at a minimum, you got to have that legal capacity. The legal capacity is actually a little higher for this one because this a will is generally lower, but you do need to have legal capacity, meaning you know what you're doing, it's your decision, no one's pressuring you to do it. It needs to be signed by you. You are called the principal at that point. It needs to be witnessed by at least one disinterested witness, and it has to be notarized. I recommend 2. When I do this with clients, I always do 2 witnesses because other states require 2. So if you end up moving and you need to use it in another state, you generally want 2. They all line of sight test again. They got to see it. Everybody's got to see everybody signing everything. You want it to, of course, name a financial agent, so the person who you trust to do these things. You want it to nominate a conservator, again, if the court ever needed to get involved and appoint a conservator for you. It doesn't have to be the same person. Generally, you're probably going to put the same person, but and then you're going to initial blanks on the form, deciding how much power you want to give your agents. This is where a good attorney can come in to kind of explain what some of those powers are, pros and cons to each power. Why is it good to have this? Why should I not give this power? That's where an attorney can kind of come in and help. Yep, and then you need to date it, of course. Okay. So that's at a minimum. On top of that, you're going to start seeing a pattern here. You want to have backup people. Again, same reasons as before. What if they pass away before you? What if you pass away at the same time? You want to, in my opinion, address whether or not you want your agent to be able to create a trust for you later, or if you already have a trust, which is again that probate avoidance tool that you can use, address whether you want that or whether you want your agent to be able to transfer property to a trust for you. The form has an information sheet attached to the back. I leave it attached. It almost looks like you don't have to, and you don't have to. It's not legally valid, but it's literally to your agent. It says, okay, agent, you're having to step in and do this. Here's where you find information about liability. Here's how you sign your name if you're signing their checks. Here's how you do this. Here's how you do that. Here's all sorts of stuff. Here's when it terminates, right? Here's when you're not allowed to use it. Here's when you are allowed to use it. So that information sheet, again, I didn't draft it, the legislature did. I attach it to the back of the document. Again, I mentioned this already, but touching on it, analyze whether you want the power to be effective immediately as soon as you sign it, or whether you want there to actually be a doctor that examines you and certifies that you're incapacitated first. So you can see how this process helps you avoid that conservatorship, because if you don't have this, no one can get into your bank accounts, no one can do anything for you financially with your own assets without going to court to have you deemed incompetent and have a judge appoint a conservator for you. So this avoids all that for the loved ones that will be taking care of you. Again, analyze whether you want there to be checks and balances. Do you want them to report to a backup agent or a third party, just so somebody else knows what's going on, because you may not, right? Last, the third document everybody needs, no matter what, in Georgia is the Georgia Advanced Directive for Healthcare. The reason I recommend this one is because the doctors in Georgia are trained on this one in school. So that helps. You don't have to have a Georgia version if you have one from another state. It'll still be valid. It's not like the power of attorney where they're not required to honor it. It's not like that. But typically, if you're able to update to the Georgia form, you should. It gives you a say in, of course, who's going to manage your medical decisions for you. If you're in a coma or you're unable to talk to the doctors, you're unable to communicate to the doctors, somebody's got to make those decisions for you. If you don't decide who it is, again, anybody gets to raise their hand and say who's going to do it, get appointed by the court, and then goes and does it. And then you also want to decide how much power they have, just like with the financial power of attorney, as well as giving them guidance about your preferences for these tough things nobody wants to think about. End-of-life decisions, life support, burial or cremation. Do you have strong feelings about an autopsy? All those things nobody wants to think about. So at a minimum, again, legal capacity, got to have that. The creator has to actually sign it. It has to be witnessed by 2 disinterested witnesses. So this one does not have to be notarized. You just need 2 witnesses that are disinterested, meaning they're not one of your named agents. Now this one could be your beneficiaries and stuff like that. There's no restriction there. It just can't be one of your agents that you've listed. Line of sight test again, they got to watch you actually sign it. You want the agent's contact information directly on the document, address and phone number. Why is that? Well, if you are in a hospital and somebody needs to be contacted, you want them to have their phone number. So there you go. You need to put that on there. And then you want it dated. On top of that, again, You want to have a backup agent, same reasons I've already mentioned before for the other documents. You want to nominate a guardian, which is the same thing as a conservator, but a person that makes decisions about you and your medical care and where you're going to live and all that. If a court ever has to be involved, you want to say who that person is. You want to initial blanks throughout the document, indicating what your wishes are. Be careful if you're doing this on your own. It's not that intuitive. Again, this is something the legislature drafted. We don't mess with it because this is what the doctors are trained on. In some places, you will initial things you do want, and in some places, you initial things you don't want. So make sure if you're doing it on your own, be very careful and actually read what you're saying or what you're initialing. Other takeaways, don't wait until you actually are sick or in an emergency situation to do this. One, you may not be able to find an attorney or someone to help you do it that fast. Two, it's going to be a lot more expensive. Attorneys typically will charge a rush for that because they have to put aside clients that have already paid them to start working on their stuff to then put yours at the top of the pile. You may not have time to ask consent for all the people that you've named. You're making decisions under stress. Maybe you're not thinking clearly, so don't wait for that. A lot of people make that mistake. The second one is don't draft them on your own if you can help it. If your income is below a certain amount, legal aid here in Cobb County can connect you with an attorney to get your estate planning done, these 3 basic documents. And if you do it on your own, please try to make it very basic. If you have complicated wishes, definitely just spring for the attorney to do it because you may mess it up, and unintentionally, I know, but it's still, these documents aren't used until you pass away or you're incapacitated. And guess what? You can't fix it. You know, so it's just better to make sure it's done right. I've already told you it's one of the best gifts you can give your family. It saves time, stress, and grief on the back end for your agents to kind of set all this up, all that fun stuff. And then do not draft these for other people. It's a misdemeanor unless you're an attorney licensed to practice law in the state of Georgia. Some people don't realize that. I've seen financial advisors do drafting. I've seen realtors do drafting. I mean, so just be careful that whoever you're hiring, or if you are helping a family member, if you are not an attorney licensed in Georgia, don't do it. There's actually a whole panel of attorneys that prosecute these, so just be careful. That doesn't come up that often, so. Yeah.
Does that include all 3 of the documents?
Yes.
I didn't realize living will, that thought you could help somebody do a living will without.
You can do your own, but you can't. I mean, if you want to say, hey, I found this form, here you go. Right. That's different than saying, okay, let me walk you through it. Here's what it means. So it's the advice part of it, okay, and helping them decide to make decisions. So yeah, I'm glad you brought that up. So if you want to say, hey, I got this form, here's the standard form, you should do this, fine. But if you're giving advice and helping people tell them, hey, here's how to sign it, here's how many witnesses you need, all of that's legal advice. So just be very careful, you know. All right, so that covers the meat of what I wanted to, oops, let me go back. So thank you all again, and now we can have any questions or we can chat after. Yes, ma'am.
General question, if I executed these documents in a state where I used to live and I'm in the process of moving, I know I saw that you have to use updated Georgia forms, but what, is it a residence requirement? How do I know when to do what? Oh,
so it's just if you're planning to live here for a long time. Yeah, like if you're only here temporarily, yeah, there's no need to do that. It's just the differentiating term is called your domicile. So your domicile, you can have multiple residents, like you split time between here and Florida or whatever. Your domicile is the place that you're determined that is your permanent home, you're planning to be here, you're not having plans to move and that sort of thing. But no, there's no requirement that you have to change your driver's license and all that stuff, although you should if you're going to be living here, but none of that is required. There's no residency requirement. Yeah.
Thank you.
Absolutely. All right. Well, thank you all so much. Again, I'm going to hang out a little bit and answer questions if y'all have any.
Thank you all for coming, and thank you for Amanda for being here.
Yeah.
Yes, thank you. Thank you.
Absolutely. Happy to help.
I appreciate it. As I mentioned at the very beginning, the Cobb Law Library is a place for legal research for the community. So we're here Monday through Friday, 8 a.m. to 5 p.m. We have computers for patron access. We're here to help. If you did register and we have your email address, you might get a survey. This is the first program we've had in a long time, so I would
The
love
guinea
to
pig.
hear feedback, topics for other future programs you might like to have. We're working on one in May about how to finance long-term care. I promise they won't all be about probate-related issues, but if there are other topics you'd like to know about, we'll see what we can do.
Yep.
So thank you for coming.